Hi guys, welcome to my next Monday Beagle episode. My guest is today Kai Zenner. He's head of office of Axel Voss, member of European Parliament, and also digital policy advisor. Kai, welcome. Nice you're here.
Thank you very much for the invitation.
We met in Amsterdam during iTech Law conference, and you described there a Trilogue, how it's going on, what is discussed. Trilogue regarding AI Act, of course. Can you explain a bit more how it is going on?
Yes, sure. So the AI Act was presented by the Commission in 2021 already, so quite a long time ago, but yeah, especially the Parliament took a while. We really could agree on one common text. And now since July, we are, as you said, in this last stage of European policy making, the so-called trilogue between Parliament and Council, where we are trying to agree on one really final text that is then becoming the law. We are now discussing with our colleagues from the member states. And well, the big ambition from everyone is to really close these negotiations until Christmas. So there will be a last political trilogue on the 6th of December. And afterwards, probably we will need some days or maybe even some weeks to clean up the text. And then there would be the votes next year in February and March. And if everything works out, the AI Act could become law around May next year or maybe June next year.
And what's your prediction? Is it going to happen? Are you going to agree on all the points, or are there any contentious points where there's no agreement?
Yes, there are indeed. I'm always mentioning four main categories of, I always say stumbling points right now. So very heated debates on high risk use cases. There we had a small breakthrough that we agreed now on an Article 6. So how to classify or categorize if an AI system is high risk or not. But what is still missing is this list of high-risk use cases in Annex 3. This we need to do, and highly contentious, highly problematic because of very different views and this problem. Okay, if you are too specific, maybe you are creating loopholes, but if you are too general in the language, then everything is included. This same problem also applies to the second area of debated points or stumbling points that we are having in the trilogue, which is prohibitions, Article 5. So what in the future should be banned? Certain things about social scoring, emotional recognition, maybe remote biometrical identification, so facial recognition. There again, as I just said, this problem, we don't want to ban too much, but at the same time, if we are getting too narrow in our wordings, maybe there are certain loopholes. The third point is governance. There, it's basically also the question how much in the enforcement and governance of the AI Act we want to centralize, so how powerful Brussels should become. And there, of course, member states do not really like this idea of giving away national sovereignty. But if you look at the GDPR, so in data protection, there are different understandings all over Europe, different intensity of enforcing the GDPR and so on. And here we want really to learn and improve it a little bit with the AI Act. And the last topic is a very popular topic, foundation models and generative AI, where we have very different proposals from the Council and the Parliament when it comes to the wording. We have some similarities in the thinking, but it's tricky to agree there on one common text, also because the topic is so new. I would say those four are really the main points, the main stumbling points. And I call them stumbling points because I would say at the moment we have a 50-50 chance of being successful to really conclude everything until the 6th of December, at least from the political points, because it will be so difficult on those four to find a common understanding. And also beyond those 4 points, there are a lot of open technical issues or smaller political points that we also need to solve.
So you mentioned foundation models because this year is the year of foundation models. What is the difference between partners, trilogue partners on foundation models?
To say it simple and maybe also to include the Commission in their official proposal in in 2021 didn't mention foundation models or generative AI at all, because their prep work was in 19 or 2020. And in this period, generative AI was not really a big thing. Yeah, generative AI was really becoming popular with the release of ChatGPT last November. And actually, in this period before ChatGPT was released, the council proposed to regulate general purpose AI systems. What they understand about GPI is that AI Act is focusing on high-risk AI systems, and those systems have one intended purpose, for example, to scan applications for a new job, which would make them a high-risk AI system because employment in this area is listed as high risk. But there are many systems that do not only have one intended purpose, for example, scanning applications, but many. And this is why then the council added this new concept of general purpose AI systems, which is a kind of multi-purpose or almost endless purpose AI system. So if you have a look at the value chain, and here is the downstream high-risk AI system for the employment sector, then GPI, general purpose AI systems, are somewhere before. And what the council wanted to do with this addition is to help those downstream actors in the value chain to become fully compliant with the AI Act, because often, or they are the only actor that is covered by the AI Act, but often they could not really fulfill all those obligations of the AI Act without getting information from this upstream general purpose AI system provider. And this is what the council basically mostly cared about. If you now, and this is why I'm using my hands, if you now take the parliament, we even went one step further. And to be fair, many of our thinking was really coming or pushed by the release of ChatGPT and foundation models like GPT-4 or Claude or whatsoever, because we were thinking, okay, it's good to think about the general purpose AI systems, but if you really want to make sure that the value chain is working well, you need to really start at the top, at the foundation model, because there, if there is, for example, a biased data set that is being used for the training, the foundation model and all those systems that are based on this foundation models downstream will suffer under this bias in the original data set. And again, similar to the council, we wanted to make sure that the whole value chain is talking with each other, cooperating with each other. And there we completely share the council approach. Once again, the council was addressing the whole issue more downstream already. But what we wanted to do on top of the council, we established certain minimum criteria that a foundation model needs to fulfill in order to make it already safe enough, better understandable, and so on and so on. We council, the member state, and we in the European Parliament, we had similar ideas in the end. We had different ways to address the problem, and within the AI value chain, we interfered at different stages. And this is why it's now becoming a little bit tricky to agree in which stage to interfere and to which extent.
Okay, I understand. So you mentioned that it's 50-50 chances to come to an agreement before the end of the year. There are significant legislative changes in the whole world. We all read executive order of President Biden in the States. There is a new Chinese law implemented and more. And do you think that even if you succeed to close it until the end of the year, AI Act becomes the law May, June next year, then there is a transition period? And don't you think that it's still too late?
I think the European Union, was dominating the discourse on how to regulate artificial intelligence for now several years. But indeed, we were so slow in our policy making and in coming to a final agreement that now other regions of the world definitely overtook us, and maybe already too late to really trigger a Brussels effect, meaning that a lot of other regions will take over at least certain parts of our law. But I would say, well, our chances decreased, but if we are still managing to put together good AI Act, I think we still have a chance that international active companies will have the decision to take which regulation we take as our, let's say, standard. And because the European Union is going much more into detail than many other regions, I still think if we are not overdoing it, or if there is huge legal uncertainty and so on, then maybe many companies will have a look at our regulation, and at least certain parts that are making sense also from a global perspective could then become rather dominating in the world. And actually, I think one thing where the European Union could also include a lot of our ideas for the whole world is standardization, because ISO, IEEE, and so on, those international standard bodies or international fora like OECD, they are of course also looking very closely what the EU is doing. But I think that they will indeed integrate a lot of those ideas from the AI Act also in their proposals.
Like I mentioned at the beginning, we met in Amsterdam and you presented there a comprehensive map of EU regulations on the digital market. You mentioned some overlaps, conflicting laws probably. And what's your take on the current process for AI in this legal environment?
Yeah. It's a really good question that I always love to talk about. I created this overview 2 years ago, and for now I'm working there very closely together and co-publishing this overview with the think tank Bruegel, one of the two leading think tanks here in Brussels. The issue is that there are indeed so many new laws. In total, we have now 107 laws that have an effect on the digital field. And in many of those cases, it's not really clear which law is now lex specialis, which law is lex generalis. So if there's a situation that two or more laws are colliding, overlapping, interfering, whatsoever, then which law should be the dominant one? Which one prevails? This is completely unclear. And now going to the AI Act, as you asked, the AI Act is facing this problem very strongly, because there are a lot of existing legislation that is already regulating artificial intelligence. Our big hope is that the new Commission, after the next European election in June next year, is taking a little bit of time to make a really strong assessment of what is out there, how those laws are interacting with each other, how we can create a more coherent system. We have a very similar situation when it comes to the enforcement. A lot of different EU bodies or national component bodies that are also overlapping in their competences, where it's not really clear who is now responsible for a certain use case. And again, there also the hope is that the next Commission is really focusing in how we make it coherent. I'm pro regulation, but regulation should make sense, because if it doesn't do, then in the end, no one will benefit from it. Companies will face huge legal uncertainty, will not invest that much, will maybe even leave the European Union, but also civil society will have problems to get their rights, will have problems to, for example, get redressed, because if you have 5 or 10 laws that are colliding, a company that harmed a human being will always find a loophole to argue, well, maybe I violated law number 1, but law number 6, 7, 8 are actually allowing me to do what I do.
I agree. I hope that EU regulatory approach doesn't stifle innovation while safeguarding ethical and social values.
Yes.
I hope your solutions work. I keep my fingers crossed for the Trilogue and your proposal to be accepted. Thank you very much for excellent discussion. Thank you for being here. You guys join our next episode, subscribe, thumbs up. Kai, thank you for joining me.
Thank you.